Hi everybody, today's video is going to be about legal research. And in order to do legal research, you need some technical and substantive skills. So we're going to talk about what those things are. And the first thing you want to understand is what are the definitions of technical skills versus substantive skills. Well, first of all, the technical skills are where you understand as the legal research the tools that you need to find the most current legal authorities. Okay, and you must be able to cite to those authorities correctly. So having those technical skills is just knowing where to look and then knowing how to tell people where you found something. The substantive skills, this is where you take that research that you found and then you're able to prepare like a case brief or a memorandum, summarizing what you found. So do you understand the difference? The technical skills is knowing where to look and then knowing how to cite properly to those things that you found, and the substantive skills are where you actually take the information that you found and you put it into another type of a document. All right, so let's look at those technical skills first. Technical skills include finding the law, updating the law, and then citing to legal authorities. So how do you find the law? Well, first of all, you have to understand what type of case that you're dealing with. That will help you sort of narrow down things. If you're looking for a criminal law case, you're going to want to look at some criminal law authorities. If you're dealing with a civil law case, like a car accident or something, you're going to want to find cases that deal with that or statutes that deal with that. So finding the law means being able to find all of the applicable statutes and cases, whether they're favorable or unfavorable to your client, and with any secondary authorities that may apply. Secondary authorities meaning like legal encyclopedias and that kind of stuff. Okay, so where exactly do you begin whenever you want to find the law? Well, there's two different types of methods. There's the topic method, and then there's the case or statute method. Now the case or statute method is the one I use most frequently because I've been practicing law and it's the one that works best for me, and I pretty much know which cases and statutes to go to. But sometimes you don't have any idea about a particular area of the law and you're going to want to use the topic method. So, for example, if a client comes in and they have an immigration problem and nobody in the law office really has ever dealt with immigration before, so they don't know exactly where to look at the, where to find the cases and the statutes on immigration, they're going to use the topic method and they're going to learn everything they can about the topic of immigration, which will kind of help point them into the right direction. So when you're using the topic method, mostly you're going to be looking to secondary authorities first, which will point you to those primary authorities. The case or statute method is, as I said, you already know the case or the statute, and once you go there, then those cases and statutes are going to lead you to other cases and other statutes, either by using the annotations or using Shepard's citations to update your research. So updating the law is really important because, as you know, a case could have come out yesterday. The Supreme Court could have made a decision yesterday which impacts all cases from yesterday forward. So if you're not up to date on the law, it's going to be very difficult and challenging for you to properly do your research. So you always want to make sure that you update and you make sure that you're using the most current law. If you're using sources like Lexis or Westlaw to do your research, they update every 24 hours. So the law that you're finding is the most up-to-date law. And then you can also use Shepard's citations or KeyCite in Westlaw, which shows you all of the cases that have come after the one that you're looking for. So you're always going to have the most up-to-date. So how are we going to specifically update things? Because some of you may be thinking, I have no idea what you're talking about. What are Shepard's? What's KeyCite? Well, if you're going to update statutes usually when you look up like the West Virginia Code or you're looking up the United States Code, it is going to contain the most up-to-date statute. And if it's been changed or amended, it will have a notation there for you. So like I said, if you're using Lexis or Westlaw, you're going to be looking at the most up-to-date statutes because sometimes statutes are stricken as unconstitutional, sometimes they've been repealed, and sometimes they've been modified. But if you look up the particular statute, it will tell you that whenever you get there to the statute. You can also look in Shepard's citations to see what cases have come after that statute, which cases have come about that have interpreted that statute, and it will give you the result of that, whether or not it was found to be unconstitutional. But again, if you're looking in the annotated statutes themselves, that information should be there, but you can always back it up with the Shepards. For cases, there is no annotation for cases, so you do need to go to Shepard's citation or key cite, and it will show you everything that happened after that case, when it was used again, and if it was overturned for any reason. And we, as attorneys, when we talk about Shepard citations, we use the term Shepardizing. So when we are updating the law, we'll say, oh, I'm Shepardizing that. Or an attorney might say to you, hey, did you Shepardize those cases? What they mean is did you find the most recent? Did you use Shepards or some other way to update the law and make sure that it was the most current? When you cite to legal authorities, you have to do it in a particular way. I have a whole separate PowerPoint that is going to go over using those citations properly. So we're not going to talk about it here, but I wanted to make sure that you understand that part of those technical skills is making sure that you are citing properly to legal authorities. So let's move on to substantive skills. Remember, the technical skills was knowing how to find something and then knowing how to properly cite to it correctly. Substantive skills is taking those cases and those statutes that you found and putting them into a format that an attorney wants to see, like a legal memorandum. Maybe you're putting together a brief for the court. So that's what substantive skills are. There's different processes that you can use whenever you're taking that information and putting it into a correct format. You always want to obtain as much background information as you possibly can from the client. So their facts are going to be really, really important to the case at hand. So once you know the law and the client tells you the facts, you can then use that information. You want to identify the facts that are important to the law. So let's say, for example, that you have a situation where a man has been charged with leaving the scene of an accident, and he says, I didn't even know that I was in an accident. How could I have left it? I didn't even realize that I had hit that person. I didn't see them. I never, I thought I hit a pothole. In that case, you're going to want to identify the relevant facts. You're going to want to understand the law, and you're going to use that to frame what are called the legal issues. So the legal issue in that case is he says he didn't know. So the question then becomes whether or not knowledge is one of the elements of the crime of leaving the scene of an accident. I mean, do you have to know that you were actually in an accident? So then what you're going to do is you're going to find the cases, the legal authorities, and the statutes that deal with your client's situation. You're going to update that law through Shepard's, as we stated before. Then you're going to brief those statutes and cases that are on point. You're going to look at them, and you're going to write a summary for the attorney that you work for. Then you're going to not only update the attorney that you work for in the current law, then you're going to say, okay, these facts in our case are very similar maybe to facts in another case. And so we think the court is going to go in a particular direction based on precedent. And then, you're going to make sure you write that all up. And there's another brief that covers how to document those results in a memorandum. And that's also happening this week in your course. All right, well, that's all I have for this particular topic. As always, thank you very much. If you need anything, don't hesitate to reach out to myself or your instructor.